So let's see what you have responded so far. We're asking you what 1 to 2 words best describe the IP that you produce in your industry or line of work. Let's see. Valuable, yes, hopefully valuable and unique. Yes, that's the hope. Valuable and unique, that is the nature of your IP. Contract management. Yep, that's why we're here. Firstly, a little bit more information on our agenda today. In a few moments, we'll have a quick preview of what PitchMark is about before we review some of those IP clauses that you might come across in your line of work. And then we'll also let you know about our next PitchMark event, which is just 10 days away. All right, this is another QR code for you to scan. Good thing you've got your mobile phone handy. The PitchMark WhatsApp community is now live. Feel free to scan this QR code. Join us on WhatsApp, and we will preview first some of the things that you might be interested in as an innovator, as a creator, such as more information about the next events that we've got coming up, previews, special guests, and more. Good, and the QR code will disappear in a couple of seconds. I'll flash it up again towards the end of our conversation today. Meantime, we say good afternoon to Yogesh. Thanks for joining us. Okay, and this is where you are from. 4 of you have already indicated where you are based, but once again, here's the opportunity for you to let us know which part of the world you're dialing in from. On your phone, you may need to hit refresh or go to slide if you were contributing to the earlier slides. Now, you might just like to move that dropper and let us know where in the world you are. Once again, give you 30 or 40 seconds to do so. Well, Frank, I think we have some very lucky people on the line today. While it still seems the slight majority of you has had cases of your ideas being stolen, a sizable 40% of you have not had that happen before. Well, good for you, and I hope it stays that way as well. Now, we've also asked you, what's the worst case of IP theft you've experienced? Scan the QR code and let us know. And then we will also reveal what others among you have said. Really, used your logo to pitch ideas, ended up getting tenders, and then didn't notify you at all. Gosh, Frank, I think that's probably a case of passing off, isn't it?
Spot on, yeah.
Dear, oh dear. Would that now be actionable legally if somebody is passing off as your company? Especially if they're making a financial gain.
Sure.
Yep. Time to find yourself a good lawyer, it sounds like. And not keen to see details, okay, but we'll try to learn more to ensure and protect IP. Absolutely. Well, that's exactly, of course, what we are here for today. And that is indeed what PitchMark is all about. Because when you're pitching a document or perhaps submitting a tender RFP, you're replying to a request for proposal, in essence, a lot of the material you share is already part of your IP. And while there are clearly laws to deter and rather to protect you, the fact is that in some cases, the theft of IP is rather informal, rather casual, and that's where PitchMark comes in. In this slide, we're asking you whether the law fully protects your IP rights. Once again, scan the QR code on screen and join the conversation. Does the law fully protect your IP rights? Tell us what you think. Yes, no, or mostly. Well, it seems that perhaps one of the 8 of you thinks that the law protects you fully, while a solid 1 in 4 thinks it doesn't, and the rest of you think mostly. And that is, of course, precisely where PitchMark fits in. If there is a law that protects your IP, patents, for example, copyright for that matter, trademark, designs can also be registered, or as we learnt in previous weeks, perhaps the geographic region that you're in, or the plant species. All of these designs can be protected by law. The problem that you have is that when you are not necessarily bound by a contract, perhaps, as I said earlier on, perhaps you're just pitching documents in response to a request for proposal, then the types of IP theft that often happen are rather informal, rather casual. The client gets the idea and then takes it. And that's, of course, where PitchMark comes in, where we are looking to avoid litigation with all the cost, with all the time and distraction, not to mention the impact on the relationship and the uncertain outcome. We are looking to move to a deterrence mindset, and that's where PitchMark comes in. The hope is that prevention is better than cure, and we simply don't have those sort of instances of IP theft that might otherwise prevail. Now, with that in mind, let's take a look at a couple of these contracts. And here would be one example of the sorts of IP clauses that you might come across from time to time. First of all, you have statements like this one. So in the tender document, perhaps you've seen this or something like it. But when you analyze the sentence, what you'll soon find is that, of course, nothing in the contract can affect a person's right to own or license IP background, background IP. That's kind of almost obvious that nobody is able to prevent you from doing so. And it creates, in my view, a false sense that somehow this document has your best interests at heart, because it then goes on to phrases like this. Now, let's drill down on the word foreground IP. Foreground IP generally would mean that this is the intellectual property you create for the client. The glossary in the document will tell you exactly what they mean by it. But in general, foreground IP is considered to be the sorts of intellectual property where you are being paid by the contractor, or rather by the customer, and as a result, you then create the work and it is now theirs. The reasonable mind would say that that's a fairly obvious way to proceed. If you're being paid for it, then yeah, perhaps the customer should own the foreground IP. And generally, these paragraphs, if you have a read of them closely, will tell you that, in essence, that you have the authority to transfer your IP to the customer, and that you no longer lay any claim to it, right? That you assign rights, titles, and interests free from all encumbrances. So far, few of us could argue with this. If you're being paid by the customer, then yeah, why not say, sure, the IP we create for you is yours. Then, however, we get onto paragraphs like these. Unless otherwise directed in writing, have a read of this. In essence, what you're being asked here is to waive any moral rights to the works. Once again, capital M, capital R, look up the glossary to see exactly what it means. But this is a fairly tightly worded paragraph. Look at paragraph B. You must ensure that any and every individual having any moral rights to the contract work waives such rights, and where they can't be waived by law, that in essence, you then guarantee that you are not going to enforce those rights. Ouch. You can't help but wonder what it is that the customer, in this case, is hoping to achieve. It almost reads like they want the shirt off your back. Foreground IP, background IP, moral rights, these are the sorts of words that you would want to look up in the glossary, and we'll get Frank to elaborate on in a few moments. But have a look at this paragraph now. Background IP. Once you've plowed through the glossary, you might well find that this is the sorts of IP that existed in your company before you won this contract. You have certain knowledge, experience, expertise in your company. Perhaps some of it is written down. It's not in any way connected to the contract, but in essence, these paragraphs imply that the customer will have rights to those things too. And on occasion, when you read these contracts, it really does look like they lay claim to everything about your company, all the experience and expertise you've ever garnered. In paragraphs like this, you are then asked to describe if you are not able to comply with handing over your IP and which particular parts of the contract works you're unable to comply with. Gosh, that's again fairly tight, isn't it? Not only are they saying we want all the background IP, they're also saying that if you can't, you now have to tell us why not. And of course, when you're tendering for work, your thoughts are, how do I tender? How do I have a competitive bid? I don't want to now say anything that's to my disadvantage that'll make me lose this bid. If I now front up and say, these are the reasons for why I can't comply with your very onerous background IP clause, then, gosh, I'm in essence saying that I'm going to be at a disadvantage to the other tenderers. And the various clauses go on and on. So, Frank, when it comes to looking at these contracts, you really do need to read them with a fine-tooth comb, right? Sometimes they stretch over many hundreds of words and many pages. What's your experience been with these sort of tender documents?
A lot of the things you've said, you and I have looked at agreements that run well over 100 pages. We've looked at IP provisions that themselves are 15,000 words. Really important point that you brought out was that, in those slides you were showing, I jotted down about 7 or 8 terms that were capitalized: contractor, moral rights, contracted works, background IP, foreground IP, parties. Anytime in a contract you see a capitalized term, that means it does have a specific meaning for the purpose of this exercise, this document. Now, you mentioned in your remarks that, it would generally be perceived to connote this. Can't make any assumptions in a contract. So anytime you see a capitalized term, it's essential that you look it up and see what it says. And I think what we're going to find out at the end of the conversation is by doing so, you can anticipate or try to mitigate a lot of the concerns that you might otherwise have. In other words, if we define background IP properly, maybe it takes away a lot of our concerns.
Well, let's explore that some more. I mean, what sort of different meanings of background IP have you come across?
Well, I think it's a little difficult to discuss this kind of a thing in a broad, general thing. I think it would really be helpful, Mark, for our discussion if we sort of assumed a hypothetical that we can follow along with so that we can relate our examples back to that. So let's say, and I'm just pulling out of thin air, let's say you're a musician. And let's say you notice that, let's say a bank has put out a tender, a request. They want to introduce a new service and they want a 15-second musical jingle that will, be associated with this. And so let's assume that this is your fact pattern. You're the musician. You're presented with a big 100-page tender bid contract, and it's got a lot of these scary provisions that you just flashed up there. What do you do?
Yep.
So that's, I think, what we should, approach this discussion with, not rather than, we could just as easily be discussing it in the context of a software developer who's writing an app or something. But, the examples get a little different. So if we just stick with the fact pattern, maybe the discussion will be as usual. Sure. Now, with that in mind, those terms, again, you've got to ask, what are they getting into? And I think in my experience, terms like background IP and foreground IP, or sometimes it's called deliverable. Sometimes you'll see a reference to a third-party IP, sometimes a customer IP, that'll all be in there. What is being attempted is to sort of take what's being discussed, the intellectual property in this case, and put it into different baskets so that it can be understood and treated differently. Background IP has a very different meaning than foreground IP, has a very different meaning than customer IP, has a very different meaning than third-party IP. So again, the definitions are key. What the overall purpose of these clauses, in my example of bank, is to try to mitigate risk. They're asking somebody to create and deliver something to them that they want to use for their own commercial purposes. They don't want any sudden surprises. They don't want to be slowed down at the last minute because something wasn't cleared or understood or properly conveyed over. So these frightening looking documents that might run, a couple thousand words provision are designed with this in mind. If you simply said everything delivered will be owned by me, yeah, you could do that, but life is a little bit more complicated, and I think we'll flesh that out in the discussion. So, all these terms are really an attempt to provide clarity, even though sometimes it seems all they do is confuse things all the more.
Yeah, especially if you're that musician, right? I mean, you're so concerned with writing a decent jingle, I think you said in this example,
Yeah,
right?
let's say.
That yeah, and are you now necessarily going to have the legal expertise to find your way through all of these things? But can you also touch briefly on moral rights, because that didn't come up in your glossary just now? What are moral rights?
Yeah, no, I didn't jot that one down, and it should have because I saw it was a defined term. Okay, so moral rights, it depends what part of the world you wake up in and how you view the world. It's a French concept, and it has to do with something other than the economic components of your created work. It has to do with the integrity of the work itself. Sometimes can mean your reputation, sometimes could not. But the best example, a case that everybody studies in law school, there was a French artist in the 60s, and he was commissioned to paint a refrigerator. And he painted 6 separate panels, 3 on the front, 1 on each side, and 1 on the top. The purchaser of that work took those panels and cut it apart and made it into 6 separate renditions, 6 separate things you're looking at. The artist brought a claim, which he was successfully cited. He said, by tearing apart my work, you've ruined the integrity of it. It was intended as a whole piece. I had a vision. It had a particular meaning. You've stolen the integrity. You've ripped it apart. You've torn it asunder. And that's what moral rights are driving at. Either the way the appearance of the work is as a work, or perhaps your reputation. You're saying, I did something that I wasn't associated with. Credit and compensation. So moral rights are considered by the French to be inalienable, unwaivable, and perpetual. It can never be taken away. It's a human right. Other parts of the world might see it differently.
Really? So only in France, is that right?
No. I say this concept is traditionally thought of when we think of droit moral, we think of the French. They're the ones who basically taught it to us. But no, in order to be a member of these international treaties, your country has to embrace or somehow cover the concept of moral rights because they are considered to be part of what the author owns by virtue of his or her creativity. But it goes to when we see moral rights, we're talking about the integrity of the work and your right to be associated with the integrity of that work. Now, as I say, in some cases, the countries say there's nothing you can do. You have this moral right. It's yours forever. There's nothing anybody can do to get rid of it. In other countries, Singapore, United States, it's considered freely assignable, waivable. You can ignore it. You can expunge it. It is a fungible transactional widget, if you will, that you can exercise or not. That's just the way they view it.
Cool.
So
it depends.
The bank wants certainty. They don't want you coming along, and they paid for this jingle and they produce it and they put it out, but maybe they've changed something or they put it in a context that you object to. They don't want you coming back after the source and raising an objection. No matter what it is, the economic rights, the moral rights, what they're trying to do in these clauses is anticipate every possible thing that might come up and provide for it.
So, and the way you're couching it, Frank, is very much like a risk mitigation tool on the part of the customer. But, for the guitarist, for the composer who's creating this jingle for this bank, you're kind of looking at that and saying, gosh, are they trying to take everything away from me? They're trying to take all the songs that I've ever written, all the jingles I've ever produced, and they then want to deny that I was somehow the author of this particular jingle. So that's how it comes across, isn't it?
Yeah, you were just conflating background IP and moral rights together and essentially saying, we want it all. We want to be able to use it. And yes, that is essentially what they're doing. They are trying to mitigate their risk by allocating it and assigning it over to you, the person that's bringing something to them. Whatever you're bringing to me, I hold you responsible for making sure that it's clean and clear and free, and I can use it without any fettering continuing obligation to something that's out there that I didn't know about, that you didn't tell me about.
Yeah. So that sort of motivation is almost understandable. I guess the concern then is that when you read these clauses and it says you will irrevocably and free of any charge and worldwide, blah, 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 that in essence, it sounds like they really do want every piece of IP, and possibly worse, they would then want to somehow, use it to their own commercial benefit. For example, Frank, we had this conversation come up when we covered training curricula for consultants, coaches, and trainers in our previous webinar. And the concern was that if you're kind of creating this curriculum for a client and you're customizing it, all well and good, foreground IP in inverted commas. But it seemed that in this case, the customer actually wanted to not only run the course with you as the trainer, but they then wanted to create an online course using your PowerPoint slides without any payment to you to run on their learning management system. And that's obviously why innovators would be very weary, not to say suspicious, when a prospective customer wants every possible conceivable right, not only to your foreground IP, but the background IP and the moral rights and so on.
That's right. And that's why all those verbs that you flash up there, like adapt, reproduce, derive, etc. Right. Those are the things that flag out to the musician, the creator in this instance. So again, it's sort of meeting in the middle. One can imagine a worst case scenario and a best case scenario. Life is what happens in between. And yeah, I think it's fair to say that, the bank in this example we're using, for a 15-second jingle, they're not necessarily looking to screw you over and ruin your career and take you over and make you their slave. They basically want a deliverable, and they don't want anybody coming out of the woodwork and screwing it up. So that's why it may seem a little intimidating, but I don't really think that their purpose is to then knock on your door 4 weeks later. Hi, we're here to search around your background IP and see what we may or may not like. And once you roll it all out for us, and we'll have a think and we'll take it, we'll be on our way. That's not really what they're driving at, even though you're right. It could be interpreted in such a manner.
Yeah. Okay. Well, let's actually play on from that. Let's say they did that. I mean, they knocked on your door, hopefully at a more civil hour, and then said, we came for what we asked for, right? Give us all your IP rights. Just on the side, Michael McIntyre has this funny skit in one of his comedy acts where, you check the end user license agreement and of software, and, by virtue of doing that, all of a sudden Apple owns your house. I mean, is that actually even possible if you have signed all these clauses? Could they actually come to you and say, we want it all?
Okay, so it gets out of the immediate thing and brings us up into a little bit more of a macro, holistic discussion about contracts in general. A contract is nothing more than an enforceable agreement. So in your situation, the example you just presented, you hire me to do a 15-second jingle, then you show up a month later and you want to go through my recording file here and grab out this and take it away for some unrelated purpose. That the courts generally wouldn't think that's reasonable. I doubt they would enforce that. And another truism in contracts, when we're talking about these 100-page Megillas, ambiguities in contracts are generally interpreted by the courts to the detriment of the person who did the drafting. And the theory is that you're the one who had the opportunity to express your intention. If there's an ambiguity, you didn't do it clearly. So if there's a good faith mistake, we're going to rule against you. And the other sort of truism that's in contracts too is that if you've got a 100-page contract that's got 300 clauses, and one of them is just completely not workable, not enforceable, not supportable, courts will generally not throw out the entire contract because of that one. They'll typically carve out that one and keep the other 299 in there. So I don't know if that really answers your question exactly, but I think if the court were presented with a situation of, the guy showed up a month later and he wanted to take, my master recordings out of my file, and I don't imagine that they would allow that to be enforced regardless of the wording of the contract.
Right, because you did say it's not just the contract. You said it's an enforceable contract. So there is still that possibility.
I said a contract is an enforceable agreement. There's no magic to a contract. Any agreement could be a contract if it's enforceable. And then there are certain criteria to be enforceable. What does an agreement have to be? But I'm just saying that a contract is only as good as a court says it is. You and I can't make a contract to rob a bank and have a court uphold that and enforce that.
Right. Because presumably that's illegal.
It's the law. Yeah, it's one of the conditions of a contract. It has to be a legal subject matter. You can't make me sign a contract when I'm drunk and hold it against me because I won't be deemed to have had the capacity to enter that contract. You can't make a 4-year-old sign a contract and hold it against them because they're presumed not to know what the heck it is they're doing. So, there's certain criteria for any agreement to be enforceable. But if you've got an enforceable agreement, you've got a contract. That's the only point I was trying to make.
Got it. Okay. So, Frank, back to the musician who's answered a request for proposal from a bank of some sort that is now maybe running a TV commercial, perhaps. Maybe they want a signature tune, and they've now put this contract in front of you. So what do you glean from these 3 lines here?
I'm getting a good faith attempt by the drafter to provide assurance that we're just looking for what we're looking for. I'm not looking to show up at your house 4 weeks later and take something that had nothing to do with what we're talking about. Again, you see that background IP is a capitalized term, so is contract document. So you would want to make sure, a couple others in their party, make sure that these are defined in the contract you're signing or the document you're signing to your satisfaction.
Okay. So often that's a whole lot of flicking around, right? Because the glossary is often at the beginning and then you kind of have to turn the pages. Or it's quite troublesome, isn't it?
It's troublesome.
Okay, so what is it about this? Tell us what we need to be looking out for. What is it about these 3 lines that gives you a certain level of comfort that they won't be taking on you?
A straightforward reading gives the appearance that they're not trying to reach beyond, the subject of this present agreement. It says in plain words, nothing is intended to transfer anything that you already own over to me. Now, again, the concern would be therefore, but what does background IP mean? But basically, this is an attempt on, in our example, the bank part to provide assurance. Okay. Also, a little bit of protection because it's a 2-way thing. The parties are going to have to trade IP back and forth. It may be that the musician is going to have to use the bank's logo in some manner because maybe they want a note to appear at a certain time in the filmed image or something like that. So everybody is trying to say, look, let's be fair. What's yours is yours. What's mine is mine. That's what they're trying to say. They're trying to give an assurance that we're straight and honest guys.
Okay. And it's those lines, nothing is intended to transfer to any party, any background IP of another party. Okay, sounds reasonable. All right, let's look at the next one then. Have a quick read. Oh, but Frank, aren't we here back in this whole thing about background IP and 3 a.m. knocks on the door asking for every bit of detail, every IP that your company holds?
Exactly, we are. But again, if we think about it from the example that we're using, a 15-second jingle, recorded music, the bank's interest is simply in trying to utilize what they paid for, free and clear of any surprises or claims or snakes coming out of the woodwork to bite them. And this language is an attempt to do that. And again, when you see capitalized terms like supplier's background IP, that's where the lawyers on the musician side is going to want to focus in on, because you're going to want to make sure that they can reason. What they're trying to say is we want to reasonably use what we're paying for. And the other side is trying to say we don't want you to overreach and get the benefit of something that you didn't pay for and that the parties didn't contemplate. So, yeah, this looks really, really scary. But I've seen enough of them to understand in the context that this is simply their way of saying, we want to do what we can do with this. It's really not their attempt to say, I'm going to come in the middle of the night and steal your child from you and, all horrible things.
Okay, but again, help us, be specific. Like, what is it that we should be looking out for? Because as you acknowledged, it is a scary paragraph at first. What are the words that mitigate that?
Well, again, you would have to, if you had sufficiently defined supplier's background IP, you're covered.
And what happens actually if you disagree with their definition? I mean, half the time the prospective customer is going to tell you to buzz off if you want to change any of the glossary items.
Yeah,
Right?
yeah, very often, especially like with a 100-page form contract from a bank, it is going to be take it or leave it. What you want, again, it gets back to whether or not that would be enforceable. The scenario you're using is the bank shows up at your house and 4 weeks later and tries to do something that was never contemplated between the parties. How do you stop them from doing that? By building some communication around this. I might, if push were to ever come to shove and I had to go to court to stop you from doing that, maybe an email or some communication between us discussing, what do you mean by supplier's background IP? I don't want you showing up at my house and taking things that have nothing to do with you. What we would probably end up doing is end up tightening that definition of supplier's background IP to ensure that what the parties both intend is what's being expressed in the contract.
Okay. Then there are some words here which, frankly, I don't see all that often. The ones in brackets. This actually makes it look like they're also trying to be quite clear that they're not going to knock on your door in the early hours in the morning, trying to monetize your back catalog of compositions.
Yeah, I mean, again, in the example we're using just for this discussion, I've hired you to do a contract. I mean, for a commercial because I want to advertise a new service I've got. Obviously, the bank advertising its services is a commercial purpose. I think what they're really trying to say, though, somewhat inartfully, is an unrelated commercial purpose. I'll take the jingle that you created for me for my bank service, but I'm not going to put it out on a separate recording where people can go to the music store and buy it because they like recordings. I'm not going to take it and somehow make a necktie out of it. I don't know how you do that, but I think that's what they're related. I think what you can really assume they're doing is talking about unrelated commercialization purposes, because why would the bank hire you to deliver a jingle if they weren't going to somehow commercialize it?
Sure, but because I don't usually see paragraphs or words like that, this is a kind of a couple of words that self-limit from the part of the customer. Right. It's very unusual, I find. Usually the customer tries to grab whatever they can.
So at the end of the day, we've been talking about risk allocation and risk mitigation. At the end of the day, what really contracts are exercises in risk tolerance. Let's say that word's in there, and let's say they say, forget it, I'm not going to change it. Sign it, take it or leave it. You're going to have to make a decision. What do you want to do? Do you want to take the contract and run the risk that this clause might possibly come up at some future date in which you'll deal with it? Or do you dig in on your principles and say, I don't like the looks of that, and turn away the contract? So, I mean, the lawyer's job is never to advise what to do. It's to identify the implications of it so that the client can make a more informed decision. But, again, what you would do if they said, I'm not going to change a word, forget it. You might say, Jim, you'd send them back a note. I'm getting ready to sign this, but I'm a little bit concerned. My interpretation of this could mean something contrary. You're not even willing to talk to me. I'm going to sign it, but I really hope this never happens. If it then happened and you went into court, you say, Your Honor, look, this is exactly what I was concerned about. I sent him this note and I got stonewalled. Life's a choice. Do you cross the street against the road or do you wait for the light to change? It's all risk tolerance.
And so in that example, what would the court likely say? I mean, if we could look at trends, perhaps.
You lost me. What would they say if what happened?
Specific? Yeah. So if you did go to court and say, look, here are the emails where I protested against this clause and my worst fears have come true, is the court likely to listen to it?
Well, at the end of the day, like in that example, has the court taken the jingle and turned it into a necktie that has nothing to do with banking? I mean, again, it's going to depend on the facts. Because the court would probably turn to the bank and say, is this what you had in mind? Yeah. And then, by the way, you also said, but you wouldn't commercialize this. So
Oh, that's it.
I'm not quite sure what we're zooming in on at the moment. Um, but communications help. The court is presented with a record of evidence, and the parties are communicating, and they're trying to understand what each side meant, so that they can try to achieve a meeting of the minds, so to speak. And
Right.
as I said, if something just isn't clear, they're going to construe it to the detriment of the guy that held it out
Right.
and give
Because
you
they
the
had the
benefit of the
chance.
doubt. And again, that just
Yes.
doesn't sound fair, does it? I mean, in life, that just doesn't sound fair.
Let's have a look at the next clause. That's this one here.
Customer arrest supplier. Yeah, same thing. So again, this is the bank. In my example, the bank is saying to the musician, I want you to do something for me. It's create a jingle. Here's some of my IP, my logo, my some text or something like that. This is the opposite. This is the bank trying to say, I have some stuff that I own free and clear before I ever met you, and I'm going to let you use it for the purpose of our agreement, and you're deliverable to me. But that's it. You don't then get the right to go off and use it for any other purpose.
Yeah,
And
well, which is again fair enough, isn't it? If you're
yeah.
the musician, you're not likely to lay claim to all the bank's intellectual property.
Well, but here's where it could also come up, Mark, and this might be like a smaller point, but let's say you're really proud because you've done this work for the bank, and it's the ABC Global Bank, they're the biggest bank in the world, and you want to let people know that you did work for the ABC Bank. A lot of people like to put the logo of the ABC Bank on their website on a tab that says "Our customers" or something like that. Bingo! Here's where you go. Can't do it unless they allow you to do it.
Right.
So in other words, if you were to do that, they could point at that clause and say, sorry, can't do it. I
We'll
loaned you
take
my
it.
logo so that you could make your deliverable to me correct, not so that you could go off and try to seek more business for yourself by hawking me out as a satisfied customer.
Awesome. Last one, and then we'll take some questions. Lengthy, what are we looking out for in this one?
Well, again, anytime I see a capitalized term, third party, customer group. Oh, customer group. Okay.
Mm-hmm.
Third parties, supplies, small criminal association. So, the words we got to look out at, especially careful, would be the capitalized one. Now, for the purpose of our discussion, I'm going to zoom in on customer group. And here's what I'm driving at. When you have these big corporations who have these big pre-printed contracts, they may be into more things, more corporate things. So in my example, let's say it's a bank, and let's say they also have a mortgage lending division. And let's say they have an insurance company to insure against the mortgages that they're giving out to themselves. And let's say they have a real estate division who advertises the homes that they're, whatever. Customer group would mean you can take that deliverable and apply it across the board. And the concern isn't so much one of ownership. I think in this, for me, it's more of a like scope creep, if you will. You're a bank. We were talking about you wanted a jingle for your local service here in Singapore. And I did that and I priced it accordingly. But Jesus, then you've made it like the center of this ecosystem of yours that extends around the world. And my jingle's being used in 60 different countries for completely different purposes. And everybody knows it now. And, gosh, I only priced it to you for one purpose. So that would be the kind of thing that I'd zoom in on, whether or not the bank will negotiate any change in that. Don't know. But customer groups have historically been interpreted very broadly by courts. And that could mean like somebody that buys the bank the next day, or these divisions that I mentioned. It's just things that the parties didn't reasonably contemplate.
Good to know. And the not for commercialization purposes makes an appearance again. So
again, I think what they're saying is not for anything unrelated. If it was, in my example, a bank who supports themselves with a mortgage company and an insurance, it's business. The business it's in is a commercialization purpose. So I'm it's a little bit of an oxymoron. Obviously, I'm contracting with you to do something for my business utilization, but the parties don't realistically think I'm going to take it and use it for something completely unrelated.
So in all, the contract that we looked at in the last couple of minutes actually seems fairly reasonable compared to the first one.
It's how well you trust the parties. What's your risk tolerance? I think having looked at these more times than just once and seeing it for the first time, it is more benign. And if you do sort of give the other side the reason of the doubt, and you ask yourself, why would they put that in there? And again, why do we need any of this? Why can't we just have one sentence that just says everything delivered will be mine? We could, but life just doesn't typically work out that way. 6 months later, questions are going to arise. What did we actually get? Did we get the recording? Did we get the underlying composition? What about the drum loop that's in there? What about the production sequence? I don't know. So that's why these things often look really scary and intimidating. And softwares make their money. But they're just really trying to anticipate upfront everything that could go wrong and provide for it. Now, your side of the agreement, you read it, you bring it to their attention. I'm concerned that something isn't clear or isn't proper or isn't fair. The bank may or may not be willing to, in my example, may or may not be willing to entertain any changes to this. If they are, great. If they don't, at least, you built your case. You padded your file, if you will. I never intended for you to take my jingle and turn it into a necktie somehow, but that's what you did. And I wrote to you before we ever started and said, don't turn it into a necktie. And yet you did it. Your Honor.
I'm still baffled by how you would turn a jingle into a necktie, Frank. Rittman.
I don't know. Maybe like a chip or something and it just activates. I don't know. Right. Using an absurd example to illustrate a point.
We have just a handful of minutes left to take your questions now. Feel free to raise hand, unmute, or drop them into the Q&A chat that you can see at the bottom of the screen, or in your phone when you are in the QR code. In the Menti, you'll be able to see how you can pop your questions in there, and we'll endeavor to answer as many of them as we can. Frank, we also have the PitchMark WhatsApp community going. That's up here on screen. Feel free to once again scan that and join our community. First question coming in from Grant. Hello again.
Hello there. Good evening. So the question would be, and I thank you very much for today's session and just elaborating the complexity of the wording that takes place with the ownership of intellectual property. Is there a generalized term or paragraph that could be substantiated at the end of a document as an appendix or something like that would just, even if you were not to understand all the criteria that was maybe mentioned in a document, that would just validate your ownership? Is there something that you could state that would just show its intention? Is there something like that, or is that the impossible dream?
Good question, Grant. Frank?
Well, if I understood it correctly, I believe Grant was asking, is there anything that the musician in my example could simply do to say, this jingle I created is mine? Was that correct, Grant? Is that your question?
Yeah, just, if there were anything written in a tender document that you were not clear on in the sense of its terms, its uppercase lettering, that you could just substantiate something at the end that would just validate your intentions for your bid in the tender.
Well, here's something you could try. It's a good gambit. You could PitchMark your jingle and provide it in lieu of signing the tender document. Send an email, send a communication across that includes your PitchMark ownership certificate, your jingle, and your tender offer. We haven't really got into that yet, but we do have a way to sort of front load this entire process for parties who don't require such formality. So yes, a PitchMark certificate would be my easiest and fastest answer to you, Grant. Mark, would you care to elaborate on that?
Yeah, Grant, I feel your pain. And I have to tell you, I've walked away from plenty of contracts simply because I thought the contract stipulations were just too onerous. Where they actually really did say, there was one university I remember particularly some years ago where in essence they intimated that whatever curriculum you have, whatever PowerPoint slides you present in the workshop to the students in the auditorium was now theirs, and they reserved all rights, including the right to create their own learning management content, and whether you liked it or not. And then, which is the next point, to Frank's point, about actually having a conversation with them. Grant, I find this is generally of use in any tender, no matter what the IP clause says. I invite you to reflect. Perhaps you've done the same thing. Call the people whose names are listed in the RFP.
Yeah.
Have you done this? Like, you just call up and say, "Hey, Sally, just wanted to say hi. I've received your RFP and I'm going to submit a tender." Have you done this at all?
Yeah, no, I have done it. As I said, there are many cases where sometimes the wording is just unclear, and 9 times out of 10 you are on deadline trying to get something in, and you're in for a penny, in for a pound, and then you found you got your pound, but it's come back as a whopper, or they've kicked the stone down the road and it's something else that you didn't ever intend to go. And so it's just trying to understand how to, as a creative person, 9 times out of 10 you can show ownership by the creation that you've created, but what people have gone and done with your creation thereafter is, once you've gone through this process, gets unclear as to who owns what at the end of the day.
Yeah. Well, I mean, you'd expect me to say the PitchMark certificate is the way to go, and that's actually exactly what it's for, right? Is to kind of rub people's noses in it and to say, "Hey, Sally, I know this is what it says in the contract, but here's one more thing for you to think about." Just as a PS to that university example I gave you, in the end, we didn't tender. And I then called, when they then called me and said, "How come you didn't tender? We thought this would be slam dunk for you." I said, "Well, have a look at your own IP clause." "Oh, don't worry about that."
Yes, I always say that. Yes.
The girl at the office, right? And you'd be like, "No, I'm so sorry, but I can't take your word for it not to worry about it. It's here in black and white." Anyway, so we then had this discussion about, what precisely I was objecting to in this clause. And it concluded with me saying the only people who would agree to this clause are either those who actually have no valuable IP to share, so they're very happy to let you have whatever because it's not worth anything anyway, or those people who haven't read the IP clause. They'll just sign off on it, not knowing what they're signing. So yeah, I have to admit, I've become a lot more choosy about the sorts of things that we put our name under. But there's nothing like actually having a conversation with them and saying, just letting you know, I've PitchMarked this.
Yeah.
At worst, you're going to have a conversation about, which is a lot better than what we usually have. Grant,
thank you. Thank you very much.
Great. Awesome. And incidentally, if you do want to sign up for PitchMark, our next event is on the 19th of June, where we will walk you through how to use it. I did promise you another QR code. Here it is. You can sign up to pitchmark.net using this QR code. It's free to sign up. It's free to PitchMark your creative works, and then hopefully actually earn some licensing dollars when you license it to the person who wants your IP. Thanks, everybody, for joining us, including you, Frank. It's always good to hear your steady words of wisdom to cut through the legalese that your colleagues in the fraternity have written.
Well, I'm always glad to help, and these were always a lot of fun, Mark. So thanks for the initiative.
Thanks for dialing in, everybody. Scan the QR code and see you on WhatsApp and our next event on June 19th. Bye for now.